Good afternoon to all present and many congratulations on completing your law degree. I am Sarvesh Malik, advocate practicing in the Punjab Haryana High Court from the last more than 10 years. Today we are here to celebrate 75 years of the Constitution of India under the Sir B. N. Rao Memorial Lecture Series. So first of all, I would like to start this lecture by giving a short introduction on Sir B. N. Rao. Sir B. N. Rao was an Indian civil servant who played a very key role in drafting the Constitution of India that is the basic for all our laws in the country. He provided a draft to the Constituent Assembly, who in turn deliberated upon it for more than 3 years, and that's how we adopted the Constitution of our India. So, on the 75th anniversary of the Constitution of India, we reach a very important milestone in the adoption of our Constitution, and at the same time, it reminds everyone that it is the basic law which protects all the fundamental rights of our citizens, which can be enforced in the court of law. So, I would like to share some important landmarks for our Constitution of India. Constitution of India was first adopted on adopted on 26th November 1949, and it came into being on 26th January 1950. The key features of an Indian Constitution are that it is sovereign, socialist, secular, and democratic. It also creates a separation of powers between the executive, legislature, and the judiciary, which is very important so that all the three pillars of our country go in harmony with each other and protect the rights of our citizens. The fundamental rights of the Constitution are enshrined in Part 3 of the Constitution. It is one of the most cherished and celebrated aspects of our Constitution, as the fundamental rights form one of the most very basic structures of our Constitution. As you all must have studied in your law course, that the basic structure of the Constitution cannot be amended, and it is very important that it stays intact so that the fundamental rights of all the citizens of our country are duly protected. As you all must have also studied, that one of the most historic judgments with this regard is the Keshananda Bharati case law. Every time when the concept of basic structure of the Constitution of India crops up, the first and foremost judgment that is mentioned is Keshananda Bharati case. It was a landmark which protected that although Article 368 of the Constitution of India provides for the amendment of the Constitution, but you cannot tinker with the basic structure of the Constitution. It was a very important step, as it ensured that the fundamental rights which are enshrined in Part 3 of the Constitution cannot be tinkered with, even in the case of emergency. Now, one of the most distinguished factors between fundamental rights which are enshrined in Part 3 and directive principles of state policy which are enshrined in Part 4 of the Constitution of India, as you all must be knowing, that the fundamental rights are enforceable in the court of law. But on the other hand, the directive principles of state policy, although they are very important for all the states as a guiding factor in ensuring that the rule of law and even the standard of livelihood of all the citizens are maintained, but the same are not enforceable in the court of law. Now, as you all are now ready to step into the profession, you should be aware that whatever you have studied in your law degree course will be totally different when you step into court of law, because the books are not as practical and the studies are not as practical as when you step into the court it will be. Our Constitution has 5 types of writs, and those writs form a very important role when you step into the profession and are practicing in Constitution side of the law. There are 5 types of writs. The first writ is habeas corpus. The second writ is writ of mandamus. The third writ is writ of certiorari. The fourth writ is writ of quo warranto, and the fifth writ is writ of prohibition. There are various you know law various you can say examples where these the writs can be taken to the court for protecting the individual rights or even the collective rights of the citizens. Like for example, in service matters, you file a civil writ petition under Article 2 to 6, 2 to 7 of the Constitution of India whenever you feel that your client has been has not been treated equally in his service tenure, and you approach the constitutional court for protection of his rights. Also, writ of habeas corpus also plays a very important role, and in the writ of habeas corpus, you can come to the court challenging illegal custody of anyone, and also the urgency of it is that normally when you file a case in the High Court, for example, it takes 2 to 3 days to be listed. But a writ of habeas corpus, if you file in the Honorable High Court, it gets listed on the same very day. And if you succeed, a warrant officer is appointed, he goes to the place and sees whether the custody is illegal or not. Now proceeding further, we shall dive into the various aspects of the Constitution. Our Constitution is very diverse, and it has been drafted after going through constitutions of various countries, and amongst them is and also the Constitution is not just a document but a living testament and to the spirit of democracy, university, and diversity. And also you should be knowing that the Constitution of our country is one of the most lengthiest of the Constitution of the world. Proceeding further, there are various fundamental rights which the Constitution protects, and it starts from Article 14. Article 14 to 18 deals with the right to equality. Article 19 to 22 deals with the right to freedom. Article 23 to 24 deals with rights against exploitation. Right to freedom of religion are contained in Article 25 to 28, and 29 to 30 articles deal with cultural and educational rights. Article 32 is a very important article because if you invoke Article 32, you can straight away approach the Honorable Supreme Court of our country, which is the apex court of our country, and you can file a SLP, which is special leave petition. And if the leave is granted to you by the Honorable Supreme Court on any of the constitutional issue or even on various legal issues, then you can straight away invoke the jurisdiction of the Honorable Supreme Court. Now, the key features of our fundamental rights are that they apply to all citizens irrespective of their caste, religion, gender, or place of birth. As already discussed, they are enforceable in a court of law. They are absolute and qualified rights. While most of these rights are fundamental and cannot be easily altered, some can be limited under specific circumstances, for example, in cases of public order, in security of the state, or sovereignty of India. For example, when the elections are taking place, there's a code of conduct, and they impose restrictions on specific movements of the government officials, or, for example, not more than n number of people can assemble at a certain area, so on. The significance of fundamental rights are that they protect the individual liberty. They are very important for democratic functioning of a country, and one of the most important aspects of the Constitution is also judicial review. Judicial review is when the authority of the courts can be invoked to protect the rights of various citizens of our country. The fundamental rights in the Indian Constitution are vital in promoting human dignity, ensuring personal freedom, and enabling the function of our democratic society. Now, we shall also discuss in detail the 5 types of writs. Writs of habeas corpus, and I have already explained to you. Writ of mandamus. Mandamus means in Latin that we command. So mandamus can be issued to any public authority to do something which it ought to do, but is not doing in normal course of action. Writ of prohibition means to forbid or prevent. It is invoked to prohibit a lower court or a tribunal, to prevent it from acting beyond its jurisdiction or exercising authority in a matter where it has no legal power. Writ of certiorari means in Latin to be certified. It is invoked to quash an order or decision made by a lower court or authority which it has no authority under law to do so. Then writ of querulanti means in Latin by for what authority. It can be invoked if you challenge that order has been passed by an authority without having jurisdiction, or without, you can also ask that whether it was competent to pass such an order. Now, as earlier discussed, one of the most important aspects of the Constitution is its basic structure. Basic structure of our Constitution is being protected by various judgments, starting from Keshavananda Bharati, then Minerva Mills, then B.R. Bovai case, and so on. Now, some of the most important judgments of the basic structure of are Indira Gandhi versus Raj Narayan, 1975, Vaman Rao versus Union of India, 1981, S.R. Bommai, as discussed, versus Union of India, 1994, L. Chandra Kumar versus Union of India, 1997, I.R. Coelho versus State of Tamil Nadu, 2007, Narmada Bachao Andolan versus Union of India, 2000, K.K. Verma versus Union of India, 2016. So, the basic structure doctrine has evolved as a critical safeguard for protecting the fundamental values and principles enshrined in the Indian Constitution. Through these landmark judgments, the Supreme Court has ensured that Parliament's power to amend the Constitution under Article 368 of the Constitution is not unlimited, and that certain core principles such as democracy, secularism, rule of law, and judicial review remain inviolable. This approach provides a balance between the need for constitutional flexibility and imperative to maintain the integrity of the Constitution of India. Now, the role of judiciary in protecting the Constitution and its rights and its fundamental rights is very important. So, it is very imperative for us to understand the structure of the judiciary. As you must be knowing, the Supreme Court is the apex court of the country. It was established by Article 124 of the Constitution and has the power of judicial review. It can examine and decide the constitutional laws passed by the legislatives. Also, if there is a dispute between states, 2, 3, or n number of states, that dispute has to be settled by the Honorable Supreme Court. Now, moving further, India allows a federal structure with a strong central government. The Constitution divides between the union and state governments into three lists. The first is state list, second is union list, and the third is concurrent list. The union parliament can override the state laws in times of conflict, and it can also decide on various issues in the concurrent list if there is a conflict between the state and the union. As already discussed, the amendment process is contained in Article 368 of the Constitution of India. Moving further, it is very important to understand as to how the Constitution of India came into being. Constituent Assembly, consisting of various important persons like Mr. B.R. Ambedkar, and were deliberated upon the constitution of various countries to come and so that our constitution comes into being, and it was adopted after a lengthy process. Constitution is the supreme law of our land. It laid down the framework for governance, the protection of fundamental rights, and the separation of powers among the executive, legislature, and judiciary. With 395 articles divided into 22 parts, it is the longest written constitution of the world. The Constitution established an independent judiciary to protect the Constitution and its values. The Supreme Court of India, as already discussed, is the highest authority in interpreting the Constitution, and it plays a crucial role in safeguarding the rights of the citizens. Over the last 75 years, India has remained a vibrant democracy. Despite challenges like wars, emergencies, and political instability, the Constitution has provided a stable framework for governance. It has enabled peaceful transitions of power and has ensured that India continues to uphold the ideals of democracy. The Constitution has been instrumental in ensuring that India's diverse population is represented both politically and socially. The universal suffrage granted to all citizens has allowed for an inclusive political process, regardless of gender, religion, or caste. The principles of social justice laid out in the Constitution paved the way for policies aimed at improving the economic condition of India's marginalized communities. Over time, the country has seen substantial growth in various sectors, including technology and services, lifting millions out of poverty. India's constitution has become a model for other democracies, particularly in the global south. Its adaptability to India's diverse society and the challenges of a post colonial world has made it a beacon for democratic nations. While the constitution has remained a robust guide, India's journey has not been without challenges. There have been over 100 amendments with adjustments made to address changing political, economic, and social realities. Notable amendments include changes to reservation policies, the Right to Information Act, and gender equality provisions. Also, one of the most important amendments which has been carried out in the recent times, which has also addressed the education system in India. For example, Right to Education provides for free education to all from the age of 6 to 14 years. It was a very important step in ensuring that the percentage of educated people in our country goes up. As we step in the future, the constitution must continue to evolve. India's demographic shift, growing urbanization, and technological advancements pose new challenges. The constitution's core principles must adapt to these challenges while remaining true to its foundational ideas of justice, liberty, and equality. There is a growing need for greater judicial accessibility, especially for marginalized communities. For that, recently, we have also evolved the technological aspect of our courts. For example, most of the courts in our country now has the facility of video conferencing where people who could not earlier reach the courts due to far off distances can now join the courts, their proceedings through video conferencing. It is a very important aspect in progressing of our judicial system, and I believe that it is one of the most important steps and a technological boom which has paved various paths for people who could not earlier reach the honorable courts. There is a growing need for greater judicial accessibility, especially for marginalized communities. The next 75 years could focus on enhancing the justice delivery system, ensuring that all citizens have easy access to legal remedies. In an increasingly diverse and pluralistic society, the Constitution will play an even greater role in fostering social harmony. Upholding the values of secularism, freedom, and equality will remain essential for India's unity. The Constitution thrives when citizens actively participate in democracy, whether through voting, engaging in civic activism, or upholding fundamental rights. Citizens are the true custodians of the Constitution. One of the most important, like you can say, phrases that the outgoing Honorable the Chief Justice of India, Justice D.Y. Chandrachud, recently gave was to mediate and not litigate. For you upcoming lawyers, it is very important to understand the concept of mediation. For example, the phrase mediate and not litigate means that we should promote mediation among the parties, and if their disputes are settled without approaching the honorable courts through the judicial system, it would be very beneficial because it will save time, effort, and would be very economical for the parties involved. The mediation facility is established all over the country in various district forums and also honorable high courts all over the country. Even the Honorable Supreme Court has a separate cell for this facility. Also, one of the most important aspects recently which has evolved during recent times is the concept of legal aid. So, anyone, for example, the cost of litigation is going up by each passing year. But if a person who, say, is confined in custody, for example, last 3 4 years, and is unable to afford a lawyer, a decent lawyer, or any lawyer, he can approach the District Legal Service Authority or the High Court Legal Service Authority for getting free legal aid. If you get free legal aid, then a lawyer is provided to you free of cost who will conduct your case on your behalf, and you will not have to pay a single penny to the lawyer. This is a very important step so that all the citizens of our country are able to get legal aid, and no one is deprived of the of approaching the courts, which is one of the core fundamental principles of our constitution. Now, I request all of you to ask and interact with me if you have various questions on the Constitution of India, working on of different courts, and how to file various cases and draft cases in an honorable High Court, the district courts, etc. So, any questions if you have? Anyone? Yes, please.
Hello, sir.
Yes, hello.
So there are certain dilemmas related to procedure established by law and due process of law.
Okay.
Wherein Supreme Court or various courts in India are facing issues that how to distinguish between them basically.
What kind of dilemmas?
Like when it comes to fundamental rights or the violation of rights of citizens,
Yes.
or whether it comes to that the laws established or amended by the Parliament are basically valid or not.
No. See, every act of the Parliament, whether of amendment any part of the Constitution, is open to judicial review.
But the scope is the major thing, na? Like what is the scope and what scope they are offering for that judicial review?
See, if, for example, like I explained to you, under Article 32, you can directly approach the Honorable Supreme Court if it gives you permission for filing a SLP. If it grants you a leave, you can directly challenge any amendment made by the Parliament directly into the Honorable. For example, I give you an example. Recently, when Justice Kher was the Chief Justice of India, the Parliament enacted a law which tried to dissolve the concept of judges who choose among judges, which we know as the collegium system. They enacted a law, NJAC, and it tried to dissolve the concept of collegium system. But our Honorable Supreme Court heavily came down on it and struck down the new enacted law. So any law which tries to encroach upon this, like if a legislature is trying to encroach over the executive or the judiciary, our courts are the main custodian of that. Our courts are always there, and if you approach it in a timely manner and you can convince the court the core importance of the issue, which would affect millions of citizens, every time it will protect the rights of the citizens.
We go for the US case. A scenario is there, due process of law or procedure established by law. Single one is used there, and in Britain, vice versa.
Okay.
But in India, both are delicate balance of due process of law and procedure established by law is being followed. So here in India, when Parliament passes certain law, they may come across like we have followed proper procedure, and each and every minute detailing had been done from our end.
Yes.
And if at that case also our Supreme Court is going to say nullify that particular act.
Yes.
On basis of that.
See, the Honorable Supreme Court tests the legality of the law. If the due procedure has been established to frame a law, would not necessarily mean that that law cannot be struck down by the Honorable Supreme Court. Following a due procedure is one aspect, but whether it is legally valid and whether it is in conformity of various laws of the land is a totally different aspect. So in the courts we deal with that aspect. The role of the courts in our country is to interpret the law. That's it. It cannot force upon to make a law. It cannot say that, okay, you need to do this, you need to do that. That is the domain of the legislature. It also cannot encroach upon the domain of the executive, which the role of the executive is to execute the laws. So it is on the executive that how it is to execute the laws. The courts are there only to interpret the laws, and when they interpret a law and come to a certain conclusion that okay, this law means this, so that meaning is to be given effect to by the executive. And if that meaning, which after interpretation is not in conformity with the various laws of the land, then that law is to be struck down.
Only one more thing, sir.
Yeah, no problem.
So I believe that in US it's quite like rights of citizens and of course their procedures are well respected than in case of India. So,
See,
just for an instance.
if
And
you
if they are following that due process of law and they are neglecting procedure established by law, so won't you feel that they may face much more challenges than the Indian subcontinent, but they are not in actual.
see, if we compare US and India, there are various differences. You cannot equate both of them. The major issue here is the population. Let me tell you that. If we didn't have so much of population, we would be at par with the US. And the system of functioning of the country of US is totally different from India. It is not the democracy like India is. The functioning of US is different. Here, most of the functions is performed by the honorable prime minister of a country. There, the president does that. So there are very differences. It's not so easy to equate them. But if you ask me, we are at this point of time on a way better footing than any of the countries of the, like for example, the age of our country is very young. If you see the core thing of our country, for other countries like China and US, they've already reached a plateau. So I think the future is bright.
Thank you, sir.
Thank you.
I also feel that future of India
Yes,
is bright.
and with that enthusiasm, all of us should strive to achieve that. That's what I feel.
Thank you.
Thank you. So how many of you present here want to start practicing? I don't see many hands. Yes, now they are coming up. And how many of you want to become judicial officers? Okay. Practice over judiciary. Nice. Anyways, all the best, all of you present here. And thank you very much for affording me the opportunity. Thank you.